This is Mr. Richard Humphreys, a High Court judge who 2 years ago came up with an extraordinary judgment in an immigration case which has had extraordinary ramifications for our society and which is fascinating on all kinds of levels. Because for an immigration case, it kind of went off in all kinds of amazing directions into the rights of children, the rights of fathers, the rights of parents. And there were three applicants, a Nigerian man, his Irish female partner, and their as yet unborn child. And the case which was made and which Mr. Justice Humphreys upheld was that the man that the child had rights to his or her father, and that the father had rights in that relationship also, and that the family had rights even though it wasn't a married family, and so on. So it was a radical judgment, really, you know, the kind of judgment which you would think that politicians in Ireland who've been talking about progressiveness for years and years and years and years would have welcomed. But actually the government appealed every aspect of it virtually. And a week ago, back in March, 7th of March, the Supreme Court, they shot down the government's appeal, but only against the immigration elements, which were actually at that point moot, no longer relevant because the man had been deported. But they upheld every single one of the objections which the government lodged against the aspects of the judgment which were radical, including the rights of the unborn child, and the rights of non-marital family, and the rights of the father. They shut everything down. But in particular, I want to talk about the unborn child, because this is where it was really amazing that Mr. Justice Humphreys plucked out of the Constitution, out of the statute law, out of common law, out of conventions all over the place, all kinds of rights which he identified as accruing to the unborn child, outside of Article 40.3.3, which is purely about the right to life. And he said there are all kinds of things: the right to litigate, the right to property, the right to inheritance, and all kinds of things. And in particular he said, and this is where it got really interesting, that the Article 42A, which was the article added as a result of the referendum we had in 2012, which was called the Children's Referendum, or the Children's Rights Referendum, that he said that article applied to the unborn child as well, because it referred to all children. And he said the unborn child is part of all children. And the Supreme Court knocked this down as well. And that's what I want to talk about in a series of posts, because to me this is a very quite extraordinary moment, a very dark moment, because not alone are we talking here about the terrible implications that we now face with regard to the unborn child having been stripped by the Supreme Court of all rights, or all potential rights, apart from the basic right to life, which is in Article 43.3, which the government is lining up in its sights to dispose of in a referendum in May. But we see that there are many aspects that really should disquiet Irish people, because among the consequences of all this is that now it appears to me, and I don't see any way out of this, that as a result of the judgment that the Supreme Court has made, no unborn child has any right other than simply the right to continue living. And that includes not just the unwanted children, which the government is intent upon liquidating, but all unborn children. Every woman's unborn child is now deprived of rights. And I want to explore that. And so this Supreme Court judgment, which people should try and read, very difficult, complex judgment, but they should try and read it, because it's about you and your family and your children's children's children. You really need to know about it.